Welcome back to Living Outside the Matrix. My name is Nigel Howard, your host, and on the show today, we're going to be talking about the Constitution and the balance of power between the state and the people. And joining me to discuss this, it's a great pleasure to welcome William Keat, a researcher and sort of self-studied, knowledged up on the Constitution. And William's going to share with us, I think, a very useful and sort of more grown-up position than we've heard about in years gone by. Those people who remember the Freedmen movement and have heard many other claims of the power of the common law, I think will be pleasantly surprised with the subject matter of this interview. William, thank you so much for taking the time to join me today, and a warm welcome to the show.
It's great to be on, Nigel. Thank you very much indeed for having me on. Brilliant. Looking forward to it.
Fabulous. So, William, maybe you can, could you just maybe start off with, just give us a tiny bit about your background. We've got a lot to talk about, obviously, but just give us a little bit of how have you got into studying the British Constitution?
Yeah, sure, no problem. Okay, so sort of in the conventional world, I was a teacher. I started life actually as a musician, and I taught music at the Cathedral School in Winchester for a bit. A lot of very formal sounding music, lots of choral music and conducting and that kind of thing in very prestigious places. Not really understanding at the time where I'd eventually end up, Yes, I then went into teaching technology, and then gradually more and more, I was becoming more and more of a techie, and I wrote code and database systems for schools and things like that. So I've had a feet in the technical world as well, and in the business world as too. I think it was around 2006-07 that I started to. Well, I didn't start. I'd always had a sense that things were not quite right. When you have children, that's a sort of a particularly key moment, because you're investigating things like, it was around the time of Andrew Wakefield and all of that, and I was investigating things like vaccines. And so I started to look into the vaccination issue in the very early days. I'm sure many were looking at it way earlier than I was, but to me, that was quite a long time ago now. So it was around sort of 2006-07, that kind of thing. That was when it was all focused on the autism problem and thimerosal, the existence of thimerosal in vaccines. And I started to investigate the background of the pharmaceutical industry and the Rockefeller Foundation and the Carnegie Foundation and the funding of the pharmaceutical industry in America. All of that, and how allopathic medicine kind of took over from homeopathic medicine. All of that kind of thing. And then I realized that this cannot exist in isolation. You can't have a conspiracy that large, using the C word, conspiracy, unashamedly. Yeah, exactly. You can't have that large in isolation. There's something so seriously wrong here that really it's got to be practically everything. So I started to look into other things like the geopolitical games that are played on the international stage, going into how our Western governments largely go into other nations and destabilize and mind control, all kinds of nudging, psychological control and then producing foreign wars on the basis of manipulation and all of that sort of stuff. So I was very interested in that, and I started to look into the sort of parallel systems of government that act behind the scenes, secret societies, government think tanks that don't exist in officially.
Yes.
Things like the Tavistock Institute, the Round Table groups, the Royal Institute for International Affairs, all of that sort of stuff, and the Fabian Society. Big stuff, actually.
That's
and
fantastic.
Then I realized that everything is just absolutely, frankly, up for grabs. It's so that was it. And then I realized that actually all of this is sort of, we're looking at different things and symptoms, and realized that ultimately the only way to kind of fix this really is to get to the bottom of, because all of it relates really in a way to government out of control, in a sense, legitimacy or a lack of legitimacy of governance. And if you haven't got your governance under control, then frankly, you're going to get all kinds of things happening. You're going to get sort of stratospheric aerosol programs going on, or whatever it may be. And so I realized that I had to look at law, and I was quite interested anyway. So I started to look at the constitutional law, and then it went from there. So that was rather a long introduction, but yes.
No, well, that's great because I mean, you painted loads of really useful coordinates there, and it's really interesting because you do need a broad context to be able to see the importance of this subject, and getting to the fundamentals and observing full context are two very key, the important elements of knowing what's going on and being an effective citizen, I think, or effective human being.
Yeah.
So. What is it that, you kind of answered my first question. I was going to say, what's the big deal about the Constitution? Why do we need to know about it? But you've kind of answered that rather well there in your introduction. It's fantastic. I guess, I mean, please feel free to add in, but it seems to me like, we're losing a lot of our freedoms. Just very recently, with the alleged pandemic, we had even the sort of sniff of mandatory vaccination programs. Now, freedom is very much lost when things like that start to happen. So,
Yes.
I mean, if you do you have any other reasons that you think, alarm bells that you can see that should call people to this cause?
Yeah, the whole subject is absolutely huge and far bigger than people realize, actually, because in a way, as I often joke with people who are close to me in this topic, it's not really about constitutional law either. It's really about natural law. It's about the subject of consciousness. It's about the relationship that we have with our consciousness and lies and truth, really reality. And that takes us into some really deep, fairly esoteric subjects, which we could come on to maybe a little bit later. But the reason why I start with constitutional law is because most people out there, even in the freedom movement, are desperately wanting some kind of solution. They want a way in. They want something tangible that they can grab hold of. And so if I just plowed in there and said, well, it's all about consciousness, that's it. That's the end of conversation at that point. It's just, it's not going to go there. And the problem actually with the consciousness subject is that it takes us into shadow work. It takes us into the necessary examination of ourselves at a society level and at ourselves at an individual level as well. And that's not popular. It's not generally liked. Most people will shy away from that pretty quickly.
No, I mean, most people can grasp freedom as, a fundamental motivating thing. We all want to be able to do what we want to be able to do. We don't want to be bullied around and told and ordered and cattle prodded here and there. But in a very real sense, we want to be able to sort of take control of our lives and be master of our own destiny. And I think there's a lot of evidence that the ability to do that is diminishing. So hence, I think this constitutional thing, and it's interesting because the free man movement, of 10, 15 years ago was trying to sort of pick up this constitutional thing and find holes in it. And it was under the premise that you could sort of get into their camp and use their rules against them and somehow find freedom, which I don't think is the case. And I'm sure you don't either. But the common law thing, a lot of people sort of have a bit of a yawn when we hear the common law, because unfortunately, maybe a lot of people have sort of, championed it unsuccessfully and without really thinking it through in the past. But it all comes down to this, or correct me if I'm wrong, but does it all come down to this Magna Carta 1215 document? Is that a good place to start?
It's certainly part of it, and I'll come on to that. And just to clarify those things that you rightly brought up there, people associate common law because it's become tainted with those actions that people have been taking in their system. When people have been engaging with various actions involving trust law, involving various types of admiralty law merchant, uniform commercial code, all of these things, I'm not claiming for a moment that these things aren't necessarily real. I think that the problem is it's really hard to prove it with a high degree of proof, because more and more I'm talking to people who are using these things, and supposedly they claim actually very successfully. And quite often when I get into conversations with them, it's actually that it's not necessarily that successful, and it is some of the time. and often we find that any success that they may have had might be for other reasons that they
Yes.
might not necessarily have thought about as well.
Yeah.
So there are a lot of claims that are being kind of thrown around, like, the whole legal profession knows exactly what's going on and all lawyers know. And that's not the case. Absolutely no way is that the case. And it's a very big oversimplification of the problem. It's largely that actually people behind the scenes, or in the system, I should say, just haven't been educated right. But the other thing that's important to say is that when people have been engaging in these processes, they talk about common law, but actually very quickly they're not using common law at all. Okay, so common law is really what underpins constitutional law. It's a real thing that is in fact the foundation of our conventional system of law. Our official system of law is actually meant to be based on common law.
Okay. Most
So
people think it's the other way around, don't they? Most people think that common law is some sort of bolt on, or
common law is a good thing because what it elevates in principle is simply the idea of the people judging the sort of moral character of their community themselves, and they do it through emplacing, for example, a natural law inspired tribunal, which is essentially our judicium parium, which is our trial by jury system.
right?
And really what that is a court of conscience.
Yeah.
It's the idea that it's the people that define the moral character of their community.
Yeah.
And if you put that the other way around, what that's basically saying is it's the people defining their liberties in their community themselves, rather than an authoritarian government. Now, that's the principle of common law, which you just couldn't argue against. Yeah. But as soon as people start sitting down and start doing processes, generally speaking, that's a technical form of law, which isn't common law. Common law is a principle-based thing, really.
Yeah.
And you don't really sit down and learn common law. Common law, in a way, is the result of decisions of juries through conscience.
Sure.
But
I always understood common law as do no harm, basically. Just don't mess with people. Live and let live. Do your own thing. Don't hurt anyone. Don't damage their property, person, or which is just common sense, really, isn't it? I mean,
right. That's exactly it. It's a good form of law, but the freemen on the land stuff wasn't really. They knew that that's how it should be, but then sort of scuttled off into the systems that the other side had put in place, illegitimately and non-transparently, not being open about it, and then run off into their systems to start playing them at their own games. Now, I think that that's dangerous, and I also think that it's not actually that honest either.
No.
Because whilst you're doing that, you're not calling out the crimes under the real system of law. Which is the constitutional law. Yeah.
And I think it's important to note also that at the base of things, this is just justice, isn't it? It's just you and me and everybody being able to do their thing, and as long as they're not hurting anyone, let them get on with it. I mean, it's just really, really basic sort of non-aggression principle kind of stuff, isn't it? That there's you could call it natural justice to it. I hesitate to use those words, but it's obviously right, isn't it? Nobody's messing with anybody else as the basis.
Yes, the principle of natural justice and individual rights stems from this idea that morality is absolute. And that's not necessarily from a religious thing. So it's a science, really. You can see morality for yourself, and in the way that it's baked into the universe. And what we're actually talking about there is natural law. And you could call it natural justice as well, if you like. That if you step outside what is, acceptable as deemed by the universe, in the way that it determines acceptable moral values, moral behavior, if you step outside that, you're going to get negative karmic consequence as a result of that, and that's something that can be observed. It's pretty objective and it's pretty scientific. So that's the study of natural law. It's an absolute morality that you can learn. And most people sort of know that at a surface level. So this idea of what we're really describing is right and wrong behavior as described by the universe. And the way that that we would learn that is by finding the edges of what is acceptable behavior. In other words, what you shouldn't do. So what you're interested in is what is is what is described in the apophatic, which is the negative. What should I not do? I can do everything else. So I've got a full landscape of rights, of right behavior. But what I'm actually trying to find is, what are the edges of those? What's the boundary? Where should I not go with that?
And the obvious answer to that is not messing with somebody, not hurting people, not forcing people, not you know. I mean, that it really is the bottom line, isn't it? I mean, how does one live? And morality is a you know, it's a big question. It's what do you do right for your life? You know, that's a whole conversation itself. I think the mainstream morality is slightly out of kilter in that it's altruism and it's all about sacrifice to the group, whereas in fact that's counter freedom. That's the morality of collectivism, which is the thing we're trying to prevent happening. And most people don't quite grasp that it's rational egoism which is the moral foundation of the politics of freedom. But maybe that's another conversation as well.
Yes, I mean, it's the idea that a collective or a group is made up of individuals. And therefore the key to it is the fact that whenever you describe a group, it's always a group of something. And it's the something that is the individuals. And therefore it's quite obvious that individual rights is key. And so coming back to the Constitution for a moment, you'll realize, and the common law system that underpins it and trial by jury, everything about the Constitution is fundamentally about individual rights. It's about the fact that it's not about the collective. You'll get collective benefits from it, but only through voluntary individual rights. The idea that it's the individual that's key, and they get protected in justice. So the very fact that, you know, under common law, you only ever receive punishment through an individual sort of customized piece of justice. It's not an off-the-peg solution like you know, like our statutory law, where they've sort of predetermined or pre-modeled some acceptable behaviors according to them or according to a group, and try to predetermine what that is. The great thing about common law justice is that it takes every single individual situation and looks at intent. It looks at you. What did you intend to do? Because it recognizes that all of us are individuals, and it's all about individual liberties and freedom. Yes, absolutely.
I love that, because I mean the principle I can see in there is that it looks specifically at the context of any alleged crime. It looks right into it, and the idea that you can prescriptively write a set of rules to sort of manage the country is unrealistic, frankly. And
yes,
this is
utterly wrong. Because
absolutely.
actually, where that ultimately takes us, if you think about it, and this is one of the great sort of discrepancies, is because everybody agrees, of course, of the dangers of order following, you know, and people look at the value of the Nuremberg trials at the end of the Second World War, and how it was realized very quickly that following orders is quite a dangerous thing to be doing. You don't get away with it. Just following orders is not a good idea. So, you know, you can do ultimately what is what somebody is trying to order you to do by first considering whether that thing is morally acceptable. But then you're not following the order. You might end up doing the thing they wanted you to do, but you first considered that it's okay, or it isn't, you know. So order following is not good. But when you think about it now, our distorted rule of law under which we're functioning now is all based on order following. Okay, so people follow orders. What they're actually doing is following statutes, and they're doing so through fear. They're not really doing it through considering every single time whether there is a sensible or good reason to do so, or it's a good moral outcome. It's just a blanket rule. So that is really about morality or moral principle. That's just about following an order because you've been told to do it. And there's nothing virtuous in following orders. Now, the other thing that's quite interesting about order following at the second layer that I give is the fact that in trial by jury, in our watered down version of trial by jury that we have now, you've got a situation where juries are following the orders of the state judge. So they're being directed. So rather than them understanding that, in fact, they have the absolute free will to agree with the legislation or not, they are told that they have to accept the orders of the judge. It's a bit more order following again. I
Yeah.
think we learned in Nuremberg trials it's not a good idea to follow orders. And on and on and on. So we haven't even mentioned the military and the police yet, but obviously there's lots of order following going on there too. So yeah.
Absolutely. An order of following, of course, is very nicely lends itself to a system of control, which is, of course, the antithesis of freedom. And I think that's where it all comes down to, things that lend themselves nicely to control. So let's jump into the jury thing, because one thing I love about your approach is that you're championing the fact that this gem at the heart of the common law is trial by jury, and it's a
Yes.
lot more than what people think it is. And the power of the jury having the ultimate sort of democratic power. So do you want to tell us a little bit about
Yeah.
the real power of the jury?
Yeah, absolutely. You're spot on. Nice description. I mean, basically, you're absolutely right that essentially common law trial by jury, genuine trial by jury that isn't in place at the moment, is much more powerful. It's essentially what's called a court of conscience, and what it basically means is that the jury are the judges completely in everything, in all aspects of the case. And most importantly, of course, is that they have the freedom, the power, and the right to judge the justice of the law, as well as the facts, and even the admissibility of evidence and the punishment, all aspects of the case. So that's what you're seeing there is a full court of conscience. Yeah, it's the people judging all aspects of the case. Now, what we have at the moment is a sort of pale imitation, where first of all, the jury are not told that they have the right to do that. They still have the right, actually, under our constitutional law, but we'll come on to this a little bit later. So the distortions that have happened and occurred along the way over 800 years and a bit more have been done by incrementally causing confusion, miseducation, indoctrination, gaslighting, a whole mix of stuff. So what you actually end up with is sometimes things that people perceive they're actually not allowed to do, and some things that have been forgotten, and it's a whole mix of things. But really, the end result is that we have a trial by jury system that's not functioning anything like it should be.
So juries convene and they actually don't know why they're there, effectively, do they? These 12 people that get summoned, they really don't know their proper role. Is that right?
Not their proper role. I mean, it's funny, really. The system is sort of kind of respectful of trial by jury, but at the same time, it's removing the full information. So you've got this kind of gaslighting, this doublethink going on, which is really how they've done it. I mean, it's basically a whole web of lies. You know, it's people in the establishment in a very uncomfortable place, not wanting to admit to themselves, and it's even stated this in writings, by the way. We couldn't possibly tell the jury that they have the full right to judge on the justice of the law, because we'd end up with anarchy. And the irony of these statements is, I mean, it's actually written down this, you can see it. And so you have sort of senior people in the establishment writing this kind of stuff, not realizing the breathtaking irony of their statements, not understanding that actually that is the way it should be, that people should be governing themselves. And of course, in doing that, in actually enacting their full powers on the jury, it actually has the effect, and we're getting into another subject here, but it has an alchemical effect. So somebody I know has just written a really wonderful bit of writing, a full dissertation on this subject called Alchemy and Annulment by Jury. So it's introducing this new term, alchemy by jury, which is this idea that by being on a jury, you're actually creating an alchemy within you. You're actually creating a raising of consciousness of people in society and yourself. Yeah, exactly.
Fantastic. I mean, if only juries knew. I mean, I've served on a jury and I've confronted a jury. been on both ends of it. But in neither cases, certainly when I was a juror, I wasn't really educated that I had
Yeah.
the capacity, or that we, the jury, I was the foreman on a jury in a GBH case, a grievous bodily harm, and we were not informed of our capacity to
Yes.
question even the legislation and the appropriateness of the rules. I mean, in that particular case of GBH, it wasn't the rules weren't up for question. It was quite clear cut.
Yeah.
But nevertheless, that power of the jury to say, hang about, what's this bloke being accused of? Should he be made to do that? Is that
Yeah.
right? Is that legislation actually right? I mean,
Yes.
is it true that the jury actually have that much power?
Yes, absolutely right. They do. And as I said, and I didn't make it clear actually what the process essentially is, and we're increasingly calling it jury independence, because it doesn't necessarily lead to a full annulment. An annulment basically just means that in that particular case, it means that that piece of legislation has definitely been ignored. That's really all annulment basically means. But you don't always know that that's the case, because there might be all sorts of reasons why a jury is not happy about the situation. And of course, you don't actually know the individual decisions of each juror either. So quite often, you don't really know whether it's a case of annulment as such. So increasingly, I'm calling it, and others around me are calling it, jury independence, which is a phrase I think that was coined by Clay Conrad in America, who's a legal professional over there, who's written some very interesting material on this subject. They call it jury nullification over
Okay.
in America. But basically, yeah, jury independence, it basically simply means that the jury has the right and the power to judge the justice of the situation independently of the legislation. That's all it means. You've got a completely free decision to decide your way, basically based on conscience, essentially.
Yeah.
And what that can lead to is a case of annulment. In that case only, annulment is basically specifically for that case, and it means that if it's obvious, it means that they have obviously passed a not guilty verdict, even though it's quite obvious that the defendant has technically broken the legislation.
Yeah.
In which case that would be a case of annulment, basically. Yeah.
Right. Maybe we should make a distinction here between case law, because obviously, when in the on the law books or whatever they call them,
Yeah.
we often refer back to a particular case where this
Yes.
judgment is made. That's usually where a judge has made some intervention, or is that where the jury have, or can it be either?
It's where it can be either, but it's where a justice is actually is reviewing that situation on appeal.
Right.
So it's where it's coming back in. So we're talking about precedent, in
Precedent.
Latin what's called stare decisis. Now the problem with case law, which is what we're talking about, that's another name for it, case law, precedent, is that quite often, confusingly, again, a bit of gaslighting going on, in the legal profession, in the judiciary, it's what is often called common law, but it isn't.
Yeah.
Okay, so common law, very specifically, is legemteri, the law of the land, the ancient law of the land. It's very easy to prove from the writings in the history of law what common law is. But we've got people in the legal profession and the judiciary calling precedent or case law common law, which is incorrect. Now, the interesting thing about case law and precedent, and it took us a while to kind of review this over quite a long period of time, actually, but essentially, a lot of case law, by the way, and in fact, I've actually got it right here, actually. So this is Blackstone's criminal practice. quite a weighty tone, this one. So if you see any legal professionals disappearing into a magistrate's court looking a bit laboured, it's probably because of that. That's the thing. And I've read a little bit of it, and I have one or two people around me who are in the legal profession, much closer to that world than I am. But it's been a really interesting journey for me, because I'm a layman on this, and I've come from the sort of constitutional law specifically. But it's only recently, within the last year and a half or so, that I've got to know people in the legal profession and one in particular who's a criminal lawyer, who is very awake to this and understands it, but I'm able to see it now from the perspective of the system, which is really interesting. But what I will say is that precedent is in some cases, in a lot of cases, very well written and very interesting law. And the justices have gone into it extremely carefully, teasing out the mens rea, understanding, or the actus reus, the mens rea, that's the intent behind a case, and really looking at the justice of the situation. Right. And some really interesting case law, actually. And you can see that in most cases, they really have looked at it very carefully. Now, the question, though, ultimately is, really, should that body of case law be there at all? Because although it's good, really, in a way, under natural law, when you go deeper still, it's really, in a way, about the moment. It's about what is this situation that we're dealing with right now. We're looking at the justice of that through our consciences right now in this particular instance. How much really should we be looking back at previous cases? Because every case is individual. Yeah. So there's a lot of question marks over whether, and the problem is, of course, with case law is who owns it? Is it government? Yeah. Or is it the people? Yeah. Yeah. And so really, justice is not something that should be owned by government. Yeah. And government shouldn't really exist at all. Okay. So
that's another conversation.
Yeah, it is. And this is where this system of English law is quite remarkable, because it's the only system on the planet that has ever existed that has allowed for a nation, an organic nation, to exist, but have the people sitting in a form of anarchism, being able to live an anarchist lifestyle.
Okay, can I try and concretize that, though, for listeners? So supposing you and I are on a jury, and there's something being tried. Let's say it's something relatively innocuous. It's not because somebody's really been a bad person. It's because perhaps they've broken some government rules. So we would have the power, if assuming that the jury all come together in a little huddle. Obviously, they all get to know each other, and you share all of your perspectives on this case as it's presented, and we would have the power to say, do you know what? That rule is absurd. We don't think that rule is proper for this nation, and we're gonna actually say, this guy we're going to say not guilty, and he can go free, because it's actually the legislation that's the fault here. Is that the?
Yes,
would that
correct.
Be a realistic inaction? The people really sort of throwing out the rotten rules and exercising their democratic control.
Yes, it's important to understand that annulment only happens for that case.
Yeah,
it's not a full repeal. Okay, so there are other mechanisms in place.
Okay. But that could start to trigger a repeal. Yeah.
Yeah, absolutely right. So a full repeal would be brought about really by putting pressure on the system. And one of the ways that would have been done, because they've gone and removed it as well, is cost-free private prosecution. Now, back in the day, before we had government owning law, because essentially, in a way, not owning law, owning criminal law, in a sense. Because if you think about it, at the moment, government kind of owns it through the CPS, the Crown Prosecution Service, largely. So, you have to take crime is dealt with by government, essentially, isn't it?
Yeah.
So back in the day, it wouldn't have been like that. As pretty much everything would have been private law, in the sense that it's one party prosecuting another. It was all about two parties, one prosecuting another, essentially, even in the world of crime as well. So if you felt that you were injured, then you'd be taking action, prosecutorial action against somebody.
Okay, but may I just interject there? Because with crime, there has to have been, for a crime to have been committed, there has to be an injured party, doesn't there?
Absolutely right.
And of course, when somebody transgresses a government rule, nobody's hurt by it at all. So in fact, that's not a crime. That's
absolutely. I mean, you're right. I should have just said that straight away. That actually, yes, indeed, for a crime to exist, criminal law,
Yeah.
There really has to be an injured party. Somebody has to have been hurt in
Mm.
some way. And that's a natural law principle. You're absolutely right. Yeah.
Yeah.
Okay, but going back to the way that it used to operate is that you would bring a prosecution against somebody, and then that would be brought before the court, a trial by jury. Now, the interesting thing back in the day is that there would have been cost-free private prosecution, which would have allowed any member of the public to take take an officer of government before a court,
Yeah.
as long as it wasn't a vexatious or silly
Yes.
reason. It had to be something serious with a
So
good.
there's no financial barrier. There was no financial barrier, and there's a huge financial barrier today, isn't there?
Absolutely right. Yeah, and the CPS get involved as well. That's the other problem. So yes, so there would have been no liability protection in those days when private prosecution was functioning correctly. So any public servants could have been taken before a court and prosecuted for being part of a team of people bringing a piece of legislation that is effectively unconstitutional to the statute books, and you would have been essentially putting pressure on the establishment to repeal that piece of legislation, because other people would then be risking being brought before a court. So private prosecution was powerful, absolutely. But the other key thing as well that don't forget is that the most senior public servant, the monarch, is their primary purpose is to protect that rule of law.
Right, and this brings us on to the royal assent thing, doesn't it?
Exactly it.
So in our country, I think as it says on your website, it's the monarch who is ultimately the head of the state. Can you run us through how they act as the yet another safeguard, effectively?
Yeah, and there would have been other safeguards underneath him as well.
Yeah,
and that was the whole point, of course, of the upper house, the House of Lords, and the sort of the long-term offices that were in place, the hereditary peers. So we've been conditioned into thinking that the hereditary peers are a bunch of sort of out of touch aristocrats who, and that may be the case in some of them, but certainly not all. I mean, I've come from that world to some extent myself, and at all stratas of society, you get a mix of people who are in touch with the realities of people's lives and take it seriously, and others that don't. And that's the case with the aristocracy too. You've got some wonderful people in the aristocracy, and you've got some bloody awful, and you've got some people in between.
Yeah, absolutely.
But the hereditary peers in the House of Lords were also a check on it, and the reason why that they had this long-term office as the upper house was to check on the day-to-day concerns of the lower house, which was all about day-to-day administration, and they were balancing the sort of much more political aspects of the nation, and balancing that against the long-term concerns of the nation at a more constitutional level. That political problems of the day were not going to encroach on the liberties of the people.
Yeah.
So that was the point of the upper house before it was completely emasculated by the Blair government. But yeah, very important. And then beyond that, the next layer above that is the head of state, the monarch, the king or queen, whose solemn role is very much to check on that again and make sure that any statutes that are being proposed through bills of parliament are not going to encroach on the constitution. They're not going to encroach on the liberties of the people. Right. And they are absolutely expected, not just a right, but they're absolutely obligation as well, to refuse royal assent to any statutory legislation that would be then infringing on that. So that is the primary role of the head of state. Absolutely.
Right. So the head of state, again, part of the system of checks and balances, supposedly, and we can see it designed in there. Yes, there's some credibility. The House of Lords, what some people might call the toffs and the elite, over generations with a responsibility to sort of monitor and temper the activities of
Yes.
the legislative in Parliament. But some people might say, obviously everyone's corruptible, and you know, the House of Lords, all those people are potentially corruptible. Any human being is. Can we trust the head of state? I mean, look back through the history books over the centuries. You know, does the king or queen always do the right thing? I would say not. And in the current context where we have, excuse me, we have King Charles III over here in England, United Kingdom, who is about to be crowned next weekend, in fact.
Yeah. Yes, indeed.
He is seen by a lot of people to be in bed with Klaus Schwab and his friends at the, you know, Davos and the World Economic Forum, and very much sort of wining and dining with this sort of global collectivist club. These people who openly state their design for a global governance and collectivist nation. You know, we'll all be happy with nothing, sort of thing. How can you know, coming back to our monarch, can we trust the monarch? He's about to be crowned next week. Is it still a feasible check and balance? There's a whole lot to unpack there. So pick up whichever ball you want and run with it.
No, it isn't. It isn't a feasible check. No, I mean, the problem we've got here is that quite clearly our rule of law has become so distorted over a period of 800 years. And what is likely to be happening coming up with the coronation is a further entrenchment of that unlawful state of affairs, absolutely, right, without question.
Yeah.
And so, yes, in answer to your question, you know, can a monarch take his oath of office under the Constitution, whilst also supporting foreign influences and political powers outside the nation that are an infringement or likely to be an infringement on that constitutional law or the liberties of the people? Can he do that lawfully? No, can't. He'd be acting unlawfully according to the Constitution. So absolutely, we're going to have a constitutional crisis, no question. But we've already got loads of constitutional crises. You know, it's all right. It's nothing new there. And the reason, and the reason why, you know, I mean, the state of affairs, the condition, the lawful condition of this country is abysmal. The whole governing system is so wildly off track, and the political class and the establishment, most of the people senior in the political class, and I'm being charitable here, simply do not understand the Constitution. They absolutely do not understand it. So, I mean, and to demonstrate that, essentially, the most obvious thing to do is to say send people off to the Parliament website and have a look at what it says about parliamentary sovereignty. You know, Parliament was never designed to be sovereign, and yet every single MP, as far as that's been written to in this recent campaigns over the recent months and weeks, has responded to the same effect, basically, because they're just given information to push out to people.
This is shocking, isn't it? Excuse me interjecting again, but this is rewriting history, you know, in front of our eyes, isn't it? It's just sort of, we can say that they're ignorant, but they might be being disingenuous. They might be being deviously lying. They might be manipulative and deceptive.
Well, and that what in reality what they are being is seditious and treasonous.
Yeah.
And the problem actually is that there isn't enough of a history of us, the people, telling them that.
No.
And they're so wildly off track now, and their whole thinking about the way that the system is supposed to work is so off track that, quite frankly, the only thing that's going to bring it back is an enormous number of people learning and understanding their constitution, and absolutely consistently and zealously reminding them of how the constitution is supposed to work. That full common law trial by jury is meant to be front and center. We are meant to be the final arbiter of law through that trial by jury system. Parliament is so overpowerful anyway. Most of the laws that are being passed as legislation don't have a business to be there anyway, because really, in a sense, justice isn't about whether you have a license to do this, that, and the other. It's nothing to do with procedure. It's really only about right and wrong. So government has no business to be in that at all anyway. It's only the people that are supposed to be judging what is right and wrong ultimately,
Yeah.
at the end of the day.
But
So
it's sorry, go on.
go on.
It seems sorry. It seems that obviously a lot of people within the system there you're mentioning are ignorant of the Constitution, but I mean their ignorance is surely matched by the general public because the general level of awareness of the British
Yes,
Constitution,
correct.
awareness of our levels of freedom being lost, even that is tragically low. It's abysmally
Totally.
low. And so we're really in a situation where everyone seems to be ignorant, and much to the glee and the advantage of those who would deceive us. You know that old
And
maxim.
not only ignorant, you're absolutely right, not, ignorant, but also they don't really care either. It's I'm afraid. So we're getting into natural law here and the state of consciousness, because ultimately the question comes down to what Mark Passio talks about, the care principle, which is sort of like the eighth hermetic principle that he's added as the enclosing hermetic principle, which is, do you ultimately care enough? Actually, well, how does he put it? What do you care enough about in the world to put your will behind? And a number of conversations that I have with people and others around me who know about this stuff, with their relations and their friends, and explain about this, and they get, if they get very far into the conversation without a shutdown, it's
Yeah.
actually people around us just don't really care enough. So it's the ultimate problem is a state of consciousness,
Yes,
really.
I would totally agree. If we zoom right out and get that 30,000 foot view
Yep.
over things, we seem to be amongst a population of people who are relatively unconscious, don't we? I mean, that's the
Yes,
bottom
and so
line.
our state, exactly right. Our state of slavery, which is what we're in, if we're being honest, is actually through collectively ourselves.
Yeah,
It's not us individually; that's the
no.
smaller number, but it's the people around us, I'm
Yeah.
afraid.
And it's
Um,
tragic that situation always benefits, nefarious intent, doesn't it? And nefarious intent. As soon as people, the general level of awareness, whether or not people care or not, how
yeah,
much people know, as soon as that all goes down, evil benefits. It's the only winner, and it's a real
absolutely,
shame.
you're spot on. And the reason for that, okay, is not calling out wrongdoing. Okay,
Yes.
so the universe, and this is one of the deeper things in natural law, is that it's not about what you do or you don't. It's more about what you don't do. It's not calling out wrongdoing when it
Yes.
happens.
Yeah.
Immorality,
Yeah.
not
That's
calling
right.
it out, because and in fact that's what we're required to do. And in fact, if you boil down Article 61 of our Magna Carta, which is the lawful rebellion,
Yeah.
that in a sense is what it's saying. Okay, at the technical level, the Constitution doesn't actually compel the people to do anything. But the
Right.
only thing in the Constitution where it's sort of getting pretty close to that, where it's saying that the people must do something, is in Article 61. And the reason why it's able to do it is only because it's what the universe compels us to do, which is basically you call out the lie and you stand in the defense of truth.
Yes.
That's basically what Article 61 is doing, because it's kind of saying that you denounce the criminal system of governance and you transfer your allegiance to the barons. Okay, and essentially what that's basically meaning is, because at that point, if the crown becomes unlawful and Article 61 is invoked, which we can come on to in a minute, then essentially it's the barons that are holding the principles of good governance and the principles of the Constitution. Yeah. So
Yeah.
your allegiance is essentially not transferring to the people, the barons. It essentially means you're transferring your allegiance to good governance, to truth.
Yes.
Yes.
It's almost as though justice is more than just condemning the guilty, but it needs to be praising of the good as well, doesn't it? That half is often, obviously
Yeah.
calling
Yeah.
out the evil where we see it. For evil to profit, all you've got to have is good men doing nothing, as you rightly say.
That's it.
Um,
Not standing by when you
yeah,
know that something wrong is being done.
yeah,
Yeah.
and the
And
unsung.
belittling it and playing it down and
Yeah,
adjusting it in your mind so that it feels okay. Yeah, there's a lot of that going on. So this is what I get into when I go into the state of consciousness and our relationship between lies and truth, is that it's really interesting because it's getting into the subconscious about the fact that what we tend to do is make excuses for things. Yeah, and we suppress what we're really doing. We make it up. We make a fiction up by slightly exaggerating or justifying something. And it's the small lies that we tell ourselves that eventually, over a long period of time, turn into absolute whoppers. That's the problem.
Yeah. So, in a nutshell, though, the Constitution as it stands, whether or not it's written or not, maybe we can address that next. But as it stands, it seems as though there are checks and balances in place. The one I like best is the jury nullification one. Obviously, I don't trust the head of state further than I could throw him, and my trust in the upper house is fairly threadbare as well.
Now, yeah, exactly, yeah.
But it sounds like there is recourse for people within the existing constitution, and interestingly, parallel in the States as well, they have jury nullification, or the potential for it. Their jury structure is the same as ours. So any of you listening in the States,
you're absolutely correct. Yes,
all
all common law systems that stemmed from the English system, and so we should say, I put a video out recently actually with a colleague of mine, John Locke in Australia. Largely about Article 61, but we were talking about the Commonwealth countries as well, which I was slow to get onto. But yeah, it's important to say that any Commonwealth countries, but it also includes the United States as well, function on a common law system. Yeah, where trial by jury should be at the heart of it. Common law, genuine trial by jury, fully functioning with jury independence.
Right.
Yes.
One more question on juries, Will. How powerful are they in terms of, can a jury be convened by 12 men in the community to address some issue or some alleged corruption or wrongdoing of a public servant, or even a criminal? Is there any power there for juries? Because I know that some advocates of common law solutions have more or less sort of said that we can sort of just take things into our own hands and just convene a group and call it a jury. What do you say to that?
I disagree with that. And I disagree with it fundamentally, because ultimately, what are you going to do when you get to the enforcement stage? How are you going to hold the criminals? It's ludicrous.
Yes.
Yeah. So this whole idea that we can sort of convene our own common law courts, no, sorry.
Yes.
What you should be doing is putting all your energy into distraining and distressing, as it says in Article 61, the current system. Now, if we had hundreds of thousands of people, which I think we're getting quite close to, actually, I don't know. We've got a few 100,000 people certainly that are interested in this campaign. commonlawconstitution.org is the website where I'm making it and raising all of the importance of all of this very, very clearly on that website. But there are others doing great stuff too, like Ken Dudney from the Democracy Defined campaign as well. So there are others, not just us.
Yeah.
But the point I'm making is that really, until you've got we've let things go so far that finding some magic bullet, some little technical thing in law, and they're just going to roll over. If something lands on their desk and they go, "Oh my God, they found the little magic hidden solution." We're just going to have to back down on everything now. Yeah. It's just not going to happen, guys. It really isn't. So actually, really, this is a shaming exercise. It's all about the spotlight. It's about the weight of public scrutiny. Now, if you had hundreds of thousands of people on this, like daily, every day, asking our public servants, well, hang on a second, actually, you're not supposed to be doing that. Constitutionally, you're not supposed to be doing that. And you are supposed to be doing this. There are all kinds of things that we can call out.
Yeah.
I mean, the biggest problem actually at the moment is the fact that although we have a watered down trial by jury system, only 1% of cases reach a jury, because most of it's dealt with in the magistrates court, and a lot of cases are what I call summary only. Okay, so that means that essentially you've breached a statute. End of story. That's the way it is, and it's so you don't get judged by your peers, by your social equals.
Yeah.
So we've got a big problem.
And that would remove any potential for the jury to say, "Hang about, that rule's a load of old nonsense."
Well done, spot on,
Yeah.
exactly.
So
See, that
they put the
it's
magistrates
very
in there,
clever,
have
that.
they? Have they put the magistrates in there as this sort of deliberate sort of, I don't know, barrier or sifting mechanism to prevent?
Probably.
Yeah.
Yeah, yeah. You're absolutely right. So just to clarify what Nigel said there very astutely, is that effectively that is the best filtering mechanism to take out the power of the jury to discard legislation, essentially, to
Yeah.
create annulment, and then to hide the fact that there's a problem with legislation. And exactly right. Yeah.
Yeah. So, in terms of, I mean, it all boils down to what we can do, doesn't it? Really, everyone wants to be able to do something, and as we've said, there's no magic bullet, so forget that one. But it does seem to all come down to education, doesn't it? That
Yes.
boring old thing, come on,
So
everyone, wise up and
yeah.
get out there.
It is, and people, you see, if you go back to the time when courts of conscience were in place, so you had the court baron, you had the court leet, the 100 court. There are all these different courts, equivalent of county court and all the rest of it. They were all courts of conscience, and the reason why they were is because the people generally understood their rights and their responsibilities, but they understood their rights. Yeah,
Yes,
and they flipping exercised them. If they knew the way that things had gone now, they'd be so embarrassed
yeah,
about the way and how far we'd let it slip. And
yeah,
that's the problem, is that we have let it slip so far. So this is really going to be a shaming exercise on the part of the establishment. You guys just don't understand. You see, I say you guys, we've got to be careful when we say to the other side, to the people in the system, you guys, actually all they are is just friends and family of us.
yes, of course.
See, that's the problem, isn't it? Is that it's really just parts of our society
Yeah.
that's in there, and it's
Everyone
an
acting
education.
for convenience, and obviously we're all busy. Oh, I haven't got time to look into that.
Exactly right.
Yeah,
Yeah, and so it's an educating process. It doesn't just mean that you have to know it up here. You have to let that information and knowledge sink down a bit lower into the heart as well. Okay, because you just have to know this stuff. Yes, know the tricks, the academic tricks, and the logic behind it. So the arguments, you can bring those out when you're expressing this to people. You need to be able to do that too, but you need that harder sort of deeper understanding of it in your heart, at a more spiritual level as well, and understand that it really, in a sense, all boils down to you either have an authoritarian state or it's the people who are the final arbiter of law. Who do you want to be the final point
yes,
of authority in law? Do you want the people to be,
yes.
or do
I
you
mean,
want some authority? It's really all it comes down to,
it is,
really.
isn't it? I mean, and most people, I mean, it comes right down to do you want to be free, an individual? Do you want to take responsibility for your own life, or do you want to be
Yes,
told what to do? And
yes.
tragically, a lot of people these days would rather be told what to do than to figure it out for themselves.
Completely right,
Yeah.
because being free means being fully responsible.
Yes,
And that is actually quite scary for a lot of people.
yes, I think
So
so.
that's the question. Do you want to be free? Do you really want to be free? Because
It's
what does
hard
that
work
entail?
being free.
Yeah, exactly. Yeah,
A
yeah.
quick question about the Magna Carta. Who wrote it, on whose behalf, and can you clarify who are the free men, the barons? You hear people say, "Oh, that's not us." That it's written for a bunch of elite people. Can you clarify who it was written by and for what purpose?
Yeah, okay. So the information that I understand, and I can do some deeper research into this, and I'm always happy to keep going into it. But my understanding is that the word freeman meant something different at the time of Magna Carta, and it included all the commoners. So the churls, the cotters, the villeins, all the various parts of society, if you like. Um, Everybody was able to be on a jury, except people who were mentally not capable,
Yeah,
or the elderly, or whatever it was. I think over a certain age or something.
yeah,
Um, so the free man word basically meant everybody, and so Magna Carta, by the way, was not the beginning of our constitution. That's an important thing to say, is that
Right. Okay.
really all it is actually is the most recent declaration or the most recent statement of our constitution. 1215
Okay.
Magna Carta
Yeah.
is that. So our constitution, our common law constitution, was in place, decades, almost hundreds of years before that. Okay, and common law was extant all over Europe as well, and in fact, 200 years before Magna Carta, Emperor Conrad of Germany was expressing in almost exactly the same words as, or very similar words to Article 39 of Magna Carta in Germany, exactly the same thing, which is interesting because that's, Europe is now under Napoleonic law.
When did that change happen? From common
Europe
law?
was. Actually, I don't know. I think. I mean, that's going to be. It was really all about the tussle of the Roman Catholic Church
Right.
ultimately.
Yeah.
So, in a way, you could almost say that the Roman Catholic Church was rooting for Roman law. I think.
Yeah.
Yeah, and common law was really much more of an ancient thing, but it goes back to early Greece, early Athens.
Yeah.
Not later. It was the time of Cleisthenes.
Yeah.
Yeah.
I mean, I wouldn't want to complicate things.
Sorry, you were just about to say something. Go on.
Yeah, I wouldn't want to complicate things by mentioning canon law, but that's probably another 20-minute discussion or something. Is that something to do with the papacy?
Yeah,
and
no,
the
canon. No,
church?
you're right. Canon law. Yeah, another type of Roman law that. No, exactly right. Yeah.
Yeah.
So
But not really
common
relevant.
law.
Not really relevant to our search for a solution here. In terms of trying to avoid tyranny and the collectivist state here in the UK and in the States and
No,
in
absolutely
Commonwealth
right.
countries. So common law, as we have it, it really comes down to the power of the jury. In a nutshell, would you say that's really, and of course,
Yes.
educating the average man and woman on the street so that they could indeed be a competent jury member?
Yes. Now, just where you said, in a way, what you're asking there is, if you wanted to boil down our constitutional law into kind of two or three things,
Hmm.
okay,
Yeah.
it's basically you have a natural law tribunal where you have the people of your community judging on you and the justice of the law, not your government. Okay,
Yeah.
so you have a natural law tribunal. The second thing is that you might have a legislature. I say might, you don't have to. A legislature, which is basically an administrative government. I wouldn't call it a government. That is basically putting in place some sensible, what I call, what a statutes are supposed to be, by the way, which is a flagging up exercise, which is basically, you behaved in a certain way. You showed certain kind of behavior that it has caused us concern, so you need to come before a court. Yeah, that's really all a statute is meant to be. It doesn't have the power to punish by itself under constitutional law, right?
Yeah.
Okay, it just brings somebody before court. So you could have you could have a legislature if you wanted to write sensible statutes, and there wouldn't be that many because it's quite difficult to have statutory law, by the way, that stays on the statute book in the context of properly functioning trial by jury. But some statutes are perfectly sensible, and that's okay. And then the third thing that you're going to have is you're going to have a head of state who really is nothing more than a wise elder who has promised in perpetuity to keep all of that rule of law in place. That's it. It's really basically those three things, essentially. And you could replicate that anywhere. You can replicate it in the Amazon jungle. You can replicate it in a village, wherever. But that's really all our constitution is when it boils down to it.
Yeah, it's quite well thought out, really, isn't it? And you can see that it should work properly. It does require everyone to be educated and know what's going on. It's interesting because, about 15 years ago, I went to a jury trial and appealed to the jury wanted to appeal to them anyway on the basis of jury nullification. But I was forbidden of even mentioning the subject by the judge. It was quite funny. I was challenging the jurisdiction of the government to demand that I have planning permission to live on my own land. I was challenging the planning law, challenging the jurisdiction of the state.
Well done.
to say that I couldn't live on my own land, not build
Yes.
anything, just sort of live in a tent or a hole in the
Yeah.
ground.
Yeah.
And I was hoping that present the argument to the jury that, look, guys, I mean, obviously they wouldn't have understood it because they're all mainstream Daily Mail readers, you know, and they wouldn't have got it anyway. But at least in principle, the idea was that they could have said, do you know what, this planning system, if it says that a man can't sleep the night on his own land, you
Yeah.
know, more than 28 days a
Well
year
done.
or whatever the stupid restriction is,
Yeah.
then that's silly. We should throw
Yeah.
that out. But of course, you know, again, it comes down to the education thing. And, you know, whatever we might say to 12 men and women, you know, plucked from the electoral register these days, or however they select them, you know, the average level of knowledge isn't going to cut it, is it? It's not going
No.
to. They're not going to
It's
believe they have the power to question anything the judge says, let alone question the statute law.
You are absolutely right, and this is the problem. And it's interesting. It doesn't take much to get to pique people's interest when they are told that actually they are independent of government and of legislation.
Mm.
They can make a decision based purely on their conscience. They are free to do so. And saying it like that, you know, if you were to say to the judge, "Are you denying the fact that trial by jury is not a court of conscience? Because under constitutional law, the right of the jury is there to judge according to their conscience. Are
Yes.
you saying otherwise?"
Yeah.
Because yeah,
That would put him on his oath, wouldn't it?
yeah, definitely, yeah, that would be quite serious.
Mm.
Now, I was just going to say actually that on our website, commonlawconstitution.org, there is actually in the resources area a really interesting documentary. It's about 1 hour long, made in America, and it follows the deliberations of a jury about gun ownership, actually.
Mm-hmm.
But it's actually a case of jury nullification. Actually happens, and the whole issue comes up. The judge is not drawn on it. I think it's the prosecuting lawyer that tells the jury that they do have this right, and it's all debated in the jury, and it's just fascinating. Just
Great.
you'll get it. Your viewers should watch it. Really,
I
honestly,
want to watch it. I want to watch that. It sounds really interesting.
quite moving, actually. Yeah.
Yeah. Well, I'm clearly going to put all these websites on, you know, the blog post, and they'll all be beneath this video wherever it's published. But can you, William, you know, try and sort of wrap things up and sort of point to a few of these resources, and maybe give us a couple of words about them, or, you know, all the links will be there, of course, and I'm plugging them. For, you know, resources for people to educate, that film being one of them, and then anything people can do, signing up to things, you know, attending stuff, whatever.
Yeah, definitely. So, yeah, our campaign, as I said, is commonlawconstitution.org. That's probably the first port of call. And one of the first things that you'll see there on there is actually, I think it's the second thing, actually, is the 5 steps to understanding the Constitution. And in that, you just got, you know, one or two, sort of 5 little things that open up, just quite short in each one. And it literally would only take you 10 minutes to read through that. And technically, you would understand the Constitution once you'd read that. You know, it kind of boils it down for you. The first thing, actually, that you'll find, I probably should swap it around. The first thing you actually find at the moment on the Constitution is a link to a place where you can download a PDF statement called the Occulted Powers of the British Constitution. Occulted in that context, meaning hidden, very concealed powers of the British Constitution.
Yeah.
Download that. It's about 11, 12 pages long. But what it is a kind of a summary of everything that I've said today, and plus a bit more. But it's backed up with good academic quotations of people in the history of law who've said the things that I've said today. And if you were to have those at your fingertips and understand it, it's pretty breathtaking stuff. But all the arguments are there, and it outlines a lot of the traps and the tricks that have been played along the way in the last 800 years as to how they've confused and muddied the waters. And, you know, so download that as well. And then there's a new section with some very interesting and important articles in it. Things like the cyclic argument of statutory law, the idea that the government pretends that it can use its statutory powers to write law, but to change the constitution above it, which it can't do.
Right,
okay,
yeah.
so they have this kind of wishful thinking that they can use statutory powers to write constitutional law. Can't do that.
Yeah.
So that's an important one. I mean, there's lots of important things on there. The
Yeah.
other thing I would say actually is get over to democracydefined.org, because that was my way into understanding that and having the level of knowledge that I do have, was thanks to Ken and his research. And I would urge you actually, and in fact, I've got a page on commonlawconstitution.org as well, dedicated to, in the resources section as well, to Ken's book, which is Democracy Defined, the Manifesto. So if you really want something quite meaty to read, get that. It's all the links are there.
Okay.
And get a copy and then read that, certainly.
Yeah,
and that will open up other things, you know,
yeah.
that and that video that I told you, yes, watch that. If you want a bit of inspiration, watch 12 Angry Men, which is a classic film, all about the trial by jury, although technically they get it wrong because it's all about majority verdicts, but ignore that. It's more about the sort of the power of it and the the consciousness that comes behind it and all of that. So yeah, get into that, definitely.
Fabulous. I'll put a link to that. I watched that recently myself, actually, after seeing you chatting with somebody else and recommending it. Great film. That it's just fantastic to watch one rational man just slowly persuade a bunch of other people and slowly pick apart, the alleged evidence. It's a wonderful watch. If anyone's
they were all going to say guilty, but he was the one that held out, and he knocked all the others gradually all the way through the film, and it's amazing to watch. No, you're right, absolutely. Yeah.
Brilliant. So I don't want to take up too much of your time here, William, but one last question with regards to the coronation. Is the King Charles is obviously sort of put on a spot, one might say. I don't know what his coronation oath is going to be, but he's supposed to be guarding the sovereignty of this land. He's not going to. We know that. Well, dare I say, we know that. I suspect he isn't. Let's put it that way.
Yeah, no, you're right. There's no indication that senior people within the establishment have any idea how the Constitution is supposed to function. No. Do I naively think that it's that they don't know? Well, I think that largely, most of the way up, it is that they don't know. Do some of them know how it's really supposed to work? Yeah, of course they do.
Yeah. So could there be some sort of constitutional crisis, or do you think everything will just get sort of swept under the rug and, business as usual?
Business as usual, everything will get swept under the rug. Well, that won't be the case if huge numbers of people distrain and distress and just get very noisy and very loud consistently. Like almost daily. We need to be causing real problems here. Asking very, very awkward questions. Definitely.
Is there any mileage, do you think, in mounting some sort of challenge to whatever oath he comes out? And I assume that we're all going to hear it. I don't know whether it's spoken in private or whether it'll be published or what have you.
Well, it will be broadcast in the service because it involves the Archbishop. We do know actually that the text of the oath that he's going to be taking is going to be the version of the text that was written in statute law in 1688 under the Coronation Oath Act, which is actually treasonous because it introduced the extra line governing according to statutes in Parliament agreed on, which is not supposed to be in there. No. It's meant to be just laws and customs. Okay, because any statutes that are lawful and are in alignment with the Constitution will fall under the category of laws and customs. No problem.
Yeah.
The problem with that is that it muddies the waters, so that effectively he's going to govern according to any statutes that they think that they can pass, including unlawful ones that, So what was legislated for in 1688 in the Coronation Oath Act is actually treasonous.
Yes.
So there is an article on Common Law Constitution about that as well, because it's not the government's job to be making serious decisions about constitutional law aspects. No. That's how they gain power. They're not supposed to be writing themselves into constitutional power by doing that, essentially elevating themselves. Not allowed to do that. They're meant to be constrained and bound by the Constitution. That's what the Constitution is. It's a set of standards by which we know they are acting lawfully or criminally. And they're not acting lawfully now. So there we go.
Yeah, shocking. Well, look, William, thank you so much for taking the time to explain, with great clarity, the UK Constitution, and it certainly makes a lot more sense to me now. And from reading some of the reading matter that you've put me onto previously, fantastic. I do hope the audience have got something from this. If there's anything you'd like to say in closing to wrap it up, please feel free. Otherwise, it's just a great big thank you for coming on and saying all this good stuff. And I shall be putting all the links to the new Chartist Movement website, the constitutiongroup.org, and was it Democracy Now, at least?
The main one really is just commonlawconstitution.org.
Okay.
That's the site. New Chartist Movement's an old campaign. Yeah,
Okay.
there's some interesting things on it, but that's less relevant now. But
Okay.
commonlawconstitution.org is the website. And no, it's a great pleasure, Nigel. And it was fun to do. We got a lot of subjects covered there, far more than I usually do, actually. Yeah. So your listeners are super listeners. They're going to be taking in a lot of information there. So thank you very much for the opportunity. It's been really good.
Wonderful. Well, thank you so much for coming on and eloquently explaining it all. Thank you all so much for listening as well. And do check out the website, lawfulrebel.com. There's loads more on there, and may even be publishing some various things, including that 11-page document. If assuming that's okay to do that, Will, that might well Absolutely be going up on the website.
Yeah, no problem.
So yeah, do check out the website. And once again, thank you for listening, and join us again next time for another episode of Living Outside the Matrix.
Change you want to see.